My Lord said, is a man of character ultimately we are looking for. The appointment process can take a person to a position of CEC or EC. How their interplay role between the parties, that the appointment process is not good to. We get the best batsmen in the team. Two best batsmen fighting each other because somebody wants to open the inning and somebody wants to get to the second down. They'll fight because they're equally powerful in the team structure. So therefore, they'll always fight. That's a test of a human aspect, that who has got what kind of a qualities in that. But that has nothing to do so far as the appointment process is concerned. Appointment process, we were briefed, Maharaj, and we were discussing with the Learned Attorney General also, whether the existing structure, the manner in which the elections commission, the elections are being conducted by this body, how much role of manipulation is there? How much role? And that's the reason why this has not happened, Malazdi. We can see government after government which has been coming and going. And in fact, after these the electronic voting machines which have come, it would have been the easiest way to manipulate. If somebody would, zero complaint, nobody, not even the opposition parties, losers have ever complained, barring certain instances which have been there. But the system, I've been told, the system is of such magnitude that it doesn't allow somebody to be partisan to an extent to say that it's going to change the formation or going to affect the electoral voting to be compromised in some sense. The whole mechanism doesn't permit that somebody can go rogue. The system, and that's why we are talking of a independence of the institution, and we are not talking independence of the individual. The individual appointment.
Supposing the election commissioner is asked to take on none less than the Prime Minister himself.
Please.
Giving an example.
Yes.
Just an example.
We are testing this one.
Hypothetical example. Supposing the election commissioner sort of, is so weak-kneed.
Yes.
That he says, okay, carries with it, he doesn't get around to doing it. Will it not be a case of complete breakdown of the system then? It's just giving an example.
Yes, Malazdi.
The reason being that he is a man who's supposed to be completely insulated.
Yes.
And when you talked about character,
yes,
character consists of various components.
Various components.
Like integrity,
yes,
honesty. But one particular characteristic required is independence.
Well, certainly, yes.
Independence is, like you said, we don't care. One of your election commissioners, in fact, resigned.
Yes.
You don't want to go there.
Yes, Police.
So these are the aspects which perhaps the participation of a larger body,
yes,
instead of the cabinet, which always, as we know, it's only self-serving because it's natural.
Yes.
They would like to perpetuate themselves in power. Any party.
Please
not saying all
yes.
parties will have that.
Yes, all parties, irrespective
yes, of the political color.
Yes.
That is why from 1990, committee after committee after committee keeps reporting. There is a dire need for change. Political parties, leaders keep shouting from the rooftops. But on the ground, nothing will happen.
Well, interestingly, I'll come to the committee part also, because there is some examination. I've seen these committee reports closely. Simple example I'll give. My Lord asked a question in the morning saying that why you are still voting the expenditure and not charging it to Consolidated Fund of India. The report we read clearly say no need. There's in the same page, on the same page we were reading, the last para on that say no, this is fine. It's expenditure through voting is fine. One report saying this. So in parliamentary democratic process where the functioning of administration has been given to our various ministries, it is extremely important that these are to be evolved with the period of time. These are to be reformed or improved over a period of time. How do we do it? We acquire more knowledge, we acquire more minds to apply to it, and that's how we create these committees. When we look at a law commission, there are the functioning, and why do we go far? This court has got a, if I say, foolproof system so far as the appointment of judges are concerned. But there are stray instances where things go wrong, which come to the knowledge. The whole idea is, should we change this to an extent to find that there are stray instances which are happening? And I'm not saying this can't happen. This can happen. And second, the best of the appointment, whether that is going to set right the system inter, say, the participant or constituents of a body like this court also. Doesn't guarantee that. But all we are trying to do is to safeguard the position. And my endeavor is, when I'm particularly pointing this out as well, the appointment of a member of this commission, how important is to be considered to say that we're going to dislodge a president. If we are not dislodging, then we are going to the same position to be done. And in my respectful submission, 324 is a vacuum of the extent. How much we should look into a transparency? Is there an extent we measure? Is we measure the extent of our independence we are looking at? Well, even if somebody by any route has been appointed and government is going to be one of the participators in that whole functioning, is it going to completely eradicate so far the relationship is concerned?
You will
I'm
find
sorry.
one thing. The test denominator has changed from time to time.
Certainly,
We learn by experience.
I'm grateful, yes.
Let us talk about the judiciary in the first instance.
Yes.
There was a time when the selections were made at the literal level, just on the request being made by the Chief Justice of the state to a lawyer, please join.
Please, Manoj.
And on his request, the appointments were made, no selection process.
Please, Manoj.
That also worked very
Was
well.
one of, yes.
And we find the finest of the persons who have gone and they came to this court. One system.
Yes, certainly.
But the very system, at a later point of time, started a question mark.
Yes, Manoj.
Then we thought, no,
Yes.
this system will not work. Let us introduce a new mechanism, which is fair, open, and available for the public also to know what kind of a mechanism is on place.
Yes.
We changed it.
Yes, Manoj.
So that system introduced.
Yes.
Now we find that system is also not working.
Possibly, yes, Manoj.
Question is, so what we change ourselves? Same is the question here also.
Yes.
If you go in service jurisprudence,
Yes.
there was a time when the appointments were made purely on interview.
Yes, Manoj.
Purely on interview.
Yes.
And never questioned.
Yes, Manoj.
But later the time came that this court also intervened and the judicial verdicts came forward that no, curtail the interview.
Yes.
The decision came because the experience shows that whenever the discretion is being vested with authorities,
Yes.
it is by and large not being used for the purpose.
Yes, Manoj.
It being. We changed the
Change the
we
system.
said no,
Yes.
curtail the interview criteria and bring it to 15%, 12%, whatever according to the
Yes.
need and requirement. 100% interview has gone, almost gone.
Yes, Manoj.
So we learn by experience.
Yes.
Same thing we put to them also.
Yes, Manoj.
If the very mechanism being followed for last 70 years, it's 69 years, whatever you call it,
Yes, Manoj.
where was the occasion for the petitions to be filed and calling upon the court to intervene?
Yes, Manoj.
They were also silent. Ground realities are different. Going
Well, yes.
what we think is, and what we tell you one thing,
Please, Manoj.
we only want one thing, subject to what you say.
Please, Manoj.
We are not saying the system is not correct.
Please, Manoj.
We are not saying that the attorney said there is no trigger point.
Please, Manoj.
We don't want that the trigger point should come, then only this court should move.
Certainly, Manoj.
What we think is, we want is,
Yes.
there should be a transparent mechanism
Yes.
which to avoid all kind of reasons and complaints,
Please, Manoj.
and people should know for whom we are going to work
Please, Manoj.
in upholding the democracy which we are.
Please, Manoj.
What kind of a mechanism you can put in place?
Please, Manoj.
People are not going to question mark.
Please, Manoj.
You say no, we have a council of ministers, they advise the president, appointments are made.
Please, Manoj.
Everything goes inside.
Please, Manoj.
Now we put to you also the same proposition. Show us what mechanism you adopted
Please, Manoj.
in making the appointment day before 2 days before.
Please, Manoj.
What is your mechanism of appointment?
What is the?
If somebody asks you, you say it's all right. Somebody can question it, will come forward.
Please, Manoj.
Why should we grant you that liberty? Why can't we take a call? Yesterday we put to you. Have you brought any mechanism? Have you brought any mechanism in place in reference to which the appointment 2 days before have been made? Show us.
Right.
Or the same council of ministers and the president and goes on.
Well, I'll answer, but the attorney and.
No, you are here.
Well, I'll certainly, but since the instructors were there on this specific aspect.
Apart from instruction, are we saying that there is an underlying unease about the accountability of the Council of Ministers and the cabinet?
We are not.
Yes, that's what
We are not. Sorry, you don't understand, mister. We are not.
I just
We
want.
just want to know from you.
Yes,
We just want to know from our satisfaction.
yes.
Let us know the mechanism you adopted.
I've told you, it's on the basis of a certain convention. There is a panel prepared, there's a DO to prepare. I've said so in my notes.
Which
Therefore,
note?
there is a procedure which is being followed.
Mr.
Right.
Attorney,
Therefore, there is
ask you,
one more aspect I want to make.
Mr. Attorney, when the matter was taken up, Mr. Prashant made a mention.
Accusations can come from anywhere.
We are not saying accusation. Don't take it up.
Are we following?
We yesterday we put this
Following
question to you.
established procedure, or is there a departure?
Attorney, we put a question to you.
Yes.
And our request. For our satisfaction,
Your Lordship.
Show us the mechanism you adopted in making appointment 2 days before.
You Lordship, the note which I've given, which in the saying,
Let us,
that how on the basis of seniority, on the basis of a panel. and
election
the basis
commissioner
of-
is not on
No,
seniority. Chief election commissioner according to his own seniority.
Not only, even election commissioners are appointments on the basis of their seniority in the civil service. That's how I showed that. You
So our
see that
information is that
paragraph.
the
Please
gentleman who has
don't-
been
You
appointed
can flag off anything you
on
want, but don't show that.
Saturday, he took VRS the previous day on
That-
Friday in order to be appointed election commissioner on Saturday. This is how.
The office was vacant till since May, You're forgetting that. since May.
Show us your notes that election
No,
commissioner is also appointed by seniority.
in this note itself, I've said this is the order of their seniority,
Yes,
shows
yeah.
how they are appointed. So it is not a pick and choose at all. It's all, every successive election commission is the basis of their seniority.
No, as we
The civil
understood,
service.
as we understood.
Yeah,
from
this
the
also,
statement,
this also, and in my note.
As we
also,
understood,
Yeah.
let me clarify. We understood that the chief election commissioner is appointed amongst the election commissioner who is senior. This is
Even
what you said.
the election commissioner, your lordship, the date of birth indicates that, for instance, Mr. Krishnamurthy, his date of birth is 1940.
Sir, your request is, are you aware how much is the civil servant according to your seniority working in the ministry of
Oh, that-
central ministry?
That,
That can't seniority can't work.
whether that would be a matter for concern or an aberration, I don't know whether that would be, because then there'll be no system can work. So there has to be some system where certain premises, certain fundamentals are said to be important and
No,
relevant.
that we understood that CEC is appointed on the seniority of the election commissioner. You're right. We agree with you.
Yeah,
Subject to something comes otherwise.
yes.
We're talking about the entry level as EC.
I am talking about the entry level also. This gives you an indication. The entry level is also on the basis of a senior.
So we can take
That's-
seniority of whom? Seniority civil servant.
In the civil servant, there is a certain element of seniority. They prepare.
From where you get the guidance that only civil servants are the only persons to be considered in the role of
The parliament does not say beyond civil servants, you have a system or a selection, a panel or a pool.
Why you are confined to civil servant?
That's why we're entering into an entirely different debate. Whom should you pick up is the question. Are we entering into the debate? If there is a convention which picks up from civil servants because of their experience involved in administration and all that, then we must depart from the system. We will have a national pool of talents that will be available. Let us pick up in the national pool of talents. That is a complete departure from the convention. Unless, therefore, I said, if the convention is found to be wrong, then you're looking at where all we can pick up people will be eligible to hold the independent office. That's a very larger debate. Very larger debate. And I want to bring up 74, section, Article 74 for a minute, Lord's kind consideration. There's an inbuilt, I think, protection available there. Article 74 reads like this: there shall be a council of ministers with the Prime Minister at the head of to aid and advise the President, who shall in the exercise of his functions act in accordance with such advice. Proviso. Provided that the President may require the Council of Ministers reconsider such advice, and either generally or otherwise, and the President shall act in accordance with the advice tendered after this reconsideration. Therefore, the President has that discretion. So, in a case where the President's doubt is triggered, the President will act. Therefore, there's an inbuilt guarantee that any departure by the Cabinet or the Council of Ministers will certainly be addressed by the President. If you want to doubt the President, of course, that's a different question.
Yeah.
Therefore, there is an inbuilt guarantee available there.
I would also on that one address within my this question I'll address.
Yeah. Yes, Balbir Singh, please. Anas.
Like just straight trying to answer this question that is the being convention. Interestingly, in case of a CAG appointment, which went initially to Delhi High Court, and this came to this honorable court later, and my lords agreed with the Delhi High Court. This was the question which was there, that what do you do? What kind of a convention it is there? And I just want to point out that because that's to throw some light that what is the nature of convention which is carried out in these kind of cases. This is Gopalaswamy and others. This is 2014. I'll show later this because some debate on the manner. Let's can kindly come on to page 26, para 41.
Yeah.
Page 26, para 41.
So page ratio.
Yeah, please.
Yeah.
Please. The other decision referred to by the learned counsel for the petitioner being Royappa's case and the decision in Manaklal and Ranjit Thakur Supra are unexceptionable. In Royappa's case, the Supreme Court observed that the equality is a dynamic concept with many aspects and dimension, and it cannot be cribbed, cabined, or confined with the tradition and doctrinal limits. It was observed from the positivistic point of view, equality is antithetic to arbitrariness. It was further observed that in fact, equality and arbitrariness are sworn enemies. One belongs to the rule of law in a republic, while other to the whim and caprice of the absolute monarch. Where an act is arbitrary, it is implicit in it, it is unequal both according to the political logic and the constitutional law, and is therefore violative of Article 14. There is no denying that there should be no arbitrariness in any state action, including the appointment of the CAG. The quarrel is not with this principle. The question is whether in the facts of the present case, there has been any arbitrariness in the appointment of the respondent as the CAG. In our view, there has not. The respondent number 2 was appointed following a time-tested convention. As in the appointment of all previous CAGs in the past, so too in the present case, the CAG has been selected from amongst the civil servants who have rich and varied experience in the public administration. The procedure that has been established has worked itself into the convention over the last several decades is that the cabinet secretariat, which is headed by the cabinet secretary, who is the senior most civil servant, having knowledge about the competence and integrity of the civil servants of the government, sends the list of the shortlisted names approved by the finance minister to the Prime Minister for his consideration. The Prime Minister thereafter considers the said shortlisted name and recommends one out of the list to the President of India for his approval. After the name is approved by the President, the CAG is appointed under the warrant and seal of the President of India. This is the manner in which the appointment to the position of CAG has been made in the past, and this is the manner in which the respondent number 2 has appointed as the CAG. There has been no arbitrariness in this process. It is not as if the shortlisted, if the shortlist was not prepared by the cabinet secretary, it is not as if the finance minister did not approve the same. It is not as if the finance minister has not recommended the name to the respondent number 2 to the president. And it is not as the president has not approved the name of the respondent number 2. Therefore, the process of appointment which was followed as a convention has been followed, and there is no deviation from the same. Therefore, it cannot be said there was arbitrariness involved in the appointment of the respondent number 2 and so on. But if we look at this method, which is called convention, which is there, and in any public administration system to say that because Prime Minister is sitting with the President in terms of the conduct of business rules, and virtually somebody is be picked up without analyzing that what is the background of the person, how much experience he has got, how much period he has worked, which areas he's worked. There is certainly some kind of an application of mind in absence of any evidence which can come in a judicial review before this court, to presume that there is nothing which works except that the cherry picking which goes on. In my respectful submission, these are a convention which has worked for a very, very long time. Today, the assumption to be raised at a point saying that I will not believe you that the process is independent because you are unable to show me each file how it is being done. For the parties, this can be done. If somebody is aggrieved, one can come forward and disclose all that knowledge. But when we are testing an application of an article of the Constitution, and unlike a statutory provision which is to be looked into, whether that kind of incisive examination required to arrive at a finding that we think that something more is required and to be laid down. But the one specific, very interesting aspect on the independence of judiciary angle came in on the tenure based. In 2017, the Finance Act 2017 came and multiple tribunals were merged. One very important departure was that unlike in the respective acts, the tribunals were provided, the date of retirement was 62 years in some case, 60 in some cases. In 2017, the Finance Act said that 5 years is there and there is a provision for reappointment. The first act was not there, it was amended 2017 came. One of the argument was raised in Madras Bar to say because the tenure is 4 or 5 years and you have a power to reappointment, you can keep control over him. and therefore independence of judiciary is affected, relying on all those case laws. Court examined this position, looked into this aspect, and said that instead of 5 years is the relevant period. The 5 year has been subsequently been a new act. We made 4 years. That's also under test today, which is coming up before the court. But so far as to look at a very important factor of a tenure and very important factor of a reappointment, which is to be made by that, is it to be pitched to a level to say it is going to affect the independence of the judiciary and consequent functioning, these quasi-judicial or judicial tribunals which are going to function, is to be raised at level? The court said nothing, that can't be done. And one very more interesting aspect was also noted by Justice Nageshwar Rao in that is, can anticipation or a threat in future can be basis to declare any law unconstitutional? That was, and these were the words used in that. I can read those paras, I pointed that out specifically in Madras Bar, which has been there. The court said that this is not the examination. You need to show in a certain instance that as a matter of fact, there is arbitrariness which has, as a matter of fact, has taken place. Those are the instances where we need to look into this aspect, and then only we can act. We can't declare a law unconstitutional based on that there is a threat, there is an apprehension, there is a likelihood which is likely to happen. All these instances which are there, this is may I request if my lords can call for 2026 SCC 1.
2026
SCC page 1.
page 1.
Page 1. Yes. My lords can come to page 1.7 in this notes.
Which para you said?
Para 144 minutes. My lords were examining the Finance Act of 2017. Para 144, 145. This is on page 137. May I please? I'm sorry.
Yeah.
Hello, this is Stogi got page 137. Please understand. On examining the constitutional scheme, the statutes which had created tribunals and the precedents of this court, laying down attributes of independence of tribunal in different facets. We do not think that the power to prescribe qualification, selection procedure, and service condition of members or the other office holder of the tribunal is intended to vest solely with the legislature for all times and purposes. Policy and guidelines exist. Subject to aforesaid, the submission of the Learned Attorney General that section 184 was inserted to bring uniformity and a view to harmonize the diverse and wide-ranging qualification method of appointment across different tribunals carries weight, and in our view needs to be accepted. 145. Cautioning against the potential misuse of section 184 of the by the executive, it was vehemently argued by the Learned Counsel for the petitioner that any discretion by the executives of such power threatens and poses a risk to the independence of the tribunal. A mere possibility or eventuality of abuse of delegated power in the absence of any evidence supporting such claim cannot be a ground for striking down the provision of the Finance Act 2017. It is always open to the Constitutional Court on challenge made to the delegated legislation framed by the executives to examine whether it conforms to the parent legislation and other laws, and apply the policy and guideline test, and found contrary can be struck down. As I understand, this is a delegated legislation. So, but the question again is that can a potential threat can be a ground to say that some action is required? And second, the rules of the procedure, which whether it's a selection appointment, can only by virtue of a statute which should be provided. And these high functionaries which are operating in the functioning of the electoral democracy in the country, which is functioning fine, where the institutional setup prevents or provide a check that this should not be abused. In that case, should it be treated as there is a vacuum or a gap where the court required to step in? That's in my respectful submission, the question which requires consideration by the law.
Since you activized us on this judgment,
Yes.
we'd like to make use of the opportunity to just ask you to read para 200.
200.
201 and 218. Attorney General and Solicitor General are also here.
Yes, please.
It's an opportunity for us to just ask you this.
So let's
Page 200,
two
para
page
200, page 165.
165. Yes, please.
Presently, there are 24 statutes and it
Yes.
comes to 24 such statutes. And then paragraph 201, you may read.
Please, no, I will start with 201. Such statutory appeals that take away the inherent ability of the Supreme Court as envisaged in the Constitution to regulate cases before it by confining its consideration to cases involving most egregious of wrongs and or having the greatest impact on public interest.
And now you read para 218,
18.
218,
218.
172.
Yes. It is apparent, that's all it's apparent that the legislature has not been provided with the desired assistance so that it may rectify the anomalies which arise from the provisions of a direct appeal to Supreme Court. Considering that such direct appeals have become serious impediments to the discharge of constitutional function by this court and also affects access to the justice for citizens, it is high time that the Union of India, in consultation with either the Law Commission or any expert body, revisit such provisions under various enactments provided for direct appeals to the Supreme Court against the orders of the tribunal, and instead provide appeals to the division bench of the High Court, if at all necessary. Doing so may merit benefit in addition to the increasing and affordability of justice and more effective constitutional adjudication by this court. It would also provide an avenue for the High Court judges to keep pace with the contemporaneous evaluation in law and hence enrich them with the adequate experience before they come to this court. We direct that the Union undertake such an exercise expeditiously and preferably within a period of 6 months at the maximum and place the finding before the Parliament for the appropriate action as may deem fit.
Has anything been done? The November 19, 2019 judgment date.
Yes.
Something is going on, my lord. It's my vague recollection. But the problem, my lord, this is again from my recollection I'm saying. The problem is the statute provides that the tribunal, some of the tribunals would be presided over by
Supreme Court judges.
a former judge of this honorable court.
That is
And thereafter appeal going to the High Court, my lord, doesn't appear to be. But that logic may perhaps not be a correct logic for the simple reason that a former honorable judge of this honorable court, if delivers an award in a say 10,000 crore arbitration
Both the district court.
to the district court also.
Exactly. So that we don't know why.
I'm sorry.
On a daily basis, we encounter this. That's why we
Right.
ask you.
It's a very.
My understanding, there is no problem.
I'm sorry.
Whether the award is by the Chief Justice of India or somebody else.
No.
It has to go to a forum which is not
Competent,
prescribed.
Exactly what he
Competent. That's what I
It's
was.
not prescribed. Merely because it goes to a district judge doesn't mean that the Chief Justice of India award is being
That's right.
overruled. No.
No, it's the
It's a
tribunal
mechanism.
award, my lord, which is.
It's a mechanic. It's a authored by Chief Justice of India or judge. This court.
That's exactly what he's saying. Therefore, the order of the tribunal can also be appealed. to
Yes.
That's exactly what.
Whatsoever man by it, he might be this court.
This
Yeah.
court should be now.
I-
This court is dealing with this case. These are the cases, kind of cases
Right.
we should be.
Your lordship should be hearing. Yes.
Right.
But this has to be a constitutional court in
Absolutely.
real sense of the term.
Absolutely.
And my lord, there can
And
be.
that's why, it's rightly said, before
Right.
coming to this court, you are never a occasion to deal with.
Right.
And for the first time, through these appellate tribunals, which is their expertise, people are there. Now coming traveled straight over to this court.
You don't know what your action.
I
will
only
be.
want, my only add on, I didn't want to stop the floor.
Mr.
The anxiety,
Just 2 minutes he wants to say. Yeah.
the anxieties which are again shown in para 2 and 3 is that the nature of the jurisdiction of the court and its position as a constitutional, deliberator. If that is going to be anyway diluted, it's going to be affected, then why flood the Supreme Court with kind of appeals without
Not
Internal
contemplated,
assistance.
not contemplated by the founding fathers.
without internal assistance? Not only here, but even in the US. US, there are several instances where statutory appeals go directly to the US Supreme Court. I can give those instances. I'm not giving a comparison. But then the point of concern is without anomalies which arise from the provisions of direct appeals. Therefore, the direct appeals, if they are mechanically worded, one statute replicated elsewhere like that, then there are some anomalies even in the consideration where the court is an appellate court, a second appeal, section 100, all that.
yeah.
Notwithstanding all that, could be anomalies. That is where the anxiety of the court is supposed to be.
That's right. We are just pointing this out when Balbir Singh
That's right.
pointed
That's
it out.
For example, my lord, in the CAT, your lordships are aware,
Correct.
that it goes directly to the division bench of the High Court.
That's why, because judgment of this court.
That's-
Well, I said that
And
takeoff
Chandra
is there is a matter which requires your attention. There is a trigger point, there is something which is happening. That's where 218 comes in. So we are all coming back on the same wavelength.
We'll raise, we can. we'll
Mr.
come back.
Balbir, only one question to you.
Please, Manoj.
You have cited the judgment of the Delhi High Court,
Yes,
the CAG,
yes,
and you have asked us to go through this paragraph 14,
yes,
41, which you quoted last.
40.
But if you go to this very page, paragraph,
Yes,
there is a mechanism in place, which was placed before the court, and court has noticed it. If you come to which page you are referring to,
well,
this is
this was on page
Roman,
26.
Roman 5, the other decision.
The decision, yeah.
If you read it downwards, there was a mechanism in place.
No, this is a convention. That's what we call convention.
That's why we are requesting you.
Yes,
What is the mechanism in place in your case? You see, if you go downwards, last paragraph, in our view, there has not, respond number 2 is appointed following, you got it?
please.
Following a
Yes,
time-tested convention, and the test is there.
yes.
We want to know from you, what is the test in place in your case, as here in the CAG?
Well, my understanding is that this is what we call convention, but
God knows, we
post
check
lunch
it.
will answer this question. Post lunch I'll answer.
I'll take some time after.
Yeah.
Mr. Balbir.
Lordship is hearing this matter continue.
We continue, we continue.
Great for one.
as here in the CAG.
Well, my understanding is that this is what we call convention, but
God knows, we
post
check
lunch
it.
will answer this question. Post lunch I'll answer.
I'll take some time after.
Yeah.
Mr. Balwant.
Lordship is hearing this matter continue.
You continue, you can't keep.
Great. Yeah, please. Hello. Please, Madam. Before the break, Justice Rastogi asked me a question that since in case of a Delhi High Court CAG appointment, there was some narration of the process which has been undertaken. Well, may I request the learned AG High Court he handed over in the morning for a minute, if my lords can see.
Para
6. Para 6, Madams. Well, this was 4-pager note. Note which was given. I'll just ask one more.
Called a supplementary.
Every got
Please, Madams. Para 6, Madam. On the second page. Start with by convention. Yes, may I please, Madam? Just one aspect I would add to it, Madam. By convention, it has been established that the members of senior civil services, other serving or retired officers of the rank of a Secretary to Government of India, Chief Secretary of State Governments have been appointed as Election Commissioner, and the senior most election commissioners as Chief Election Commissioner on the basis of the database maintained by the DOPT. A list of serving and retired officers in the position of Secretary to Government of India, Chief Secretary in States is prepared. On this basis, a panel of name is then prepared. What is missing, one of the instructions are by Ministry of Law for consideration of the Prime Minister and President. The Prime Minister, after considering the panel of names, recommends one name to the President of India. A note with the recommendation is submitted to the President of India. This is the convention which is being followed. So there is a process of DOPT maintaining the list of different officers serving, and the DOPT maintains including their career track records. It is not that they only maintain that who's the senior in each ministry. So there is a lot of data being collected, and as I'm privy to, since I was arguing on reservation matter. So when they calculate, it's a very, very comprehensive data which is being maintained. Right today, it is to be identified in railway particular department, particular section, who has been appointed, his origin date of appointment, under which category, through the interview rules, through the promotion rules, which postings he have been. So all those details are being maintained. Once that list is prepared, based on that, the panel of name is given by Ministry of Law. And like any ministry, they have their own ways to look at it, which is being carried out. And based on that, the list goes to the Prime Minister with the note of recommendation.
Has there been any occasion when you have overlooked the senior most election commissioner in the matter of appointment of the chief election commissioner?
Because I can check that, but I mean, right now may not be positioned, but I can take this question and can.
We just wanted to know.
Yes, Madam.
If you are given the right to supersede,
Yes.
then you will have yes men. You'll be queuing up and they'll do whatever you wanted them to do, so that they will get to the post and satisfy them. Completely erodes seniority. I mean, independence.
Well, that can be one way to certainly that there is a
You
possibility.
don't know how you do it.
Yes, but this,
Big system has it.
well, then I think is going to be most important question would be, I mean, I'll certainly answer this one, I'm duty bound to answer this. But in each these cases, that how to what length this inquiry is to be made. We were on a convention that there's some convention which is being followed. There is some method which is there. And that method has got some basis to go because the DOPT being the highest authority which is maintaining the employment record of Government of India in different ministries. And that carries out and the panel goes to the respective ministry, which is Ministry of Law. There is some exercise carried out, the final panel name is given. So far as this is the process which is being carried out.
Yes.
I wanted to show that it appears that what is the current setup of the election commission in the country, because one aspect was raised that the need a separate secretariat. There is the independent secretariat, but currently this is available on their website also. So it's not I'm taking something from outside. That what is the current structure of the election commission?
May I just take a moment? Because the estimate on both sides is that it will continue to day 501.
May not. We have said maybe by at least by half an hour we'd like to devote to.
All right, very well. Then
We
we
want to begin.
No,
that
very well, very well. No,
By 3:30.
no problem.
So, to your lordships, would like to continue tomorrow, Manoj?
Of course we will continue.
Tomorrow, there will be some.
We'll be continuing. We'll not be breaking up the constitution bit. After this is over, we'll stay
Lordship.
up the Jallikattu.
Your lordship.
We'll just continue. The bench. No?
Grateful.
Tomorrow, there is another constitution bench, but there's no problem.
True. But then we will not break up this bench. That's all we are saying. Who wants to address us in
But
Jallikattu?
in any case, we have to address, Lord.
Well, in this matter, we would like to respond after Mr. Sharma and Mr.
That's right. We are going, let's see how we will get. Yes.
Grateful.
Well, let's may kindly see the setup which has been explained.
Yes. But we'll just keep a time on this.
Well, I'll wrap up in 10 to 15 minutes.
Yes.
The commission has a separate secretariat at New Delhi consisting of about 300 officials in a hierarchical setup. 2 or 3 deputy election commissioner and the director general, who are the senior most officer in the secretariat, assist the commission. They are generally appointed from the national civil service of the country, are selected and appointed by the commission with tenure. Directors, principal secretaries, secretaries, under secretaries, and deputy secretaries support the deputy election commissioner and director general in turn. There is a functional and territorial distribution of work in the commission. The work is organized in division, branches, and sections. Each of the last mentioned unit is in charge of section officer. The main functional divisions are planning, judicial, administration, systematic voters education, and electoral participation.
Read it as read, David.
Yes, so one can take it that.
We are just noting it, set up.
Yes, so there is a setup. Now, this setup linked with, if my lords can take the People Representation Act of 1950, 1950 People Representation Act.
1950 Act.
50 Act. The endeavor is to show how the statutory breakup of the administration of the entire exercise, going up to the last mile of declaration of result, and what is the involvement of the commission or the commissioner for that matter.
Just give us the sections.
Yes, I'll just give a.
So that, you know,
I'll just give those
you can
sections.
give a brief note if you don't know.
I'll certainly give that.
That will do. So we'll just notice as how the RP Act minimizes the importance of this is what you're trying to say.
Yes, the entire process is very, very independent. Different functionaries are allocated different jobs.
That's right.
Even this goes to the extent section 60 say, how do you declare result? No need of interference unless and until the election commissioner says that in absence of any direction.
So you just give us those sections.
Well, I can
separate
quickly-
note. We'll make it give a note by. Well, we'll see.
I'll give the note, Malas, on this what is the scheme under the People Representation Act so
Correct,
far as the
correct.
independent functioning is
That's right.
concerned.
We'll
Yes,
see.
Malas. But the one judgment which my lords have seen numerous times, the MS Gill, just one para of that I want to read.
Okay, paragraph.
Well, the last paragraph that is at. Well,
Paragraph.
my lords can take the compilation for a minute.
It just gives a drift of it. What is it? What is it?
Well, basically, there the request was made to the court that please make some guidelines so far as to build in the audio partum rule where there is a dispute in the candidature of someone. You frame those guidelines. How the court reacted to it, Malas. Well, let's may kindly see that. Yes, this is page 1384 of this minute. I'm sorry.
Paragraph you have not given.
Well, I'll just give that. Page 1445, para 130.
begin.
Yes, please, Malaj. Being not altogether certain of all the facts and circumstances that may be made available in the appropriate forum, it may be a premature exercise by this court even to lay down guidelines when there is no hidebound formula of rules of natural justice to operate in all cases and at all times when a decision has to be made. Justice and fair play have often to be harmonized with the exigencies of situation in the light of accumulated totality of circumstances in a given case, having regard to the question of prejudice, not to the mere competent in an electoral contest, but to the real and larger issue of completion of free and fair election with the rigorous promptitude. Not being adequately informed of all facts and circumstances, this court will not make the task of election commissioner difficult and embarrassing by suggesting guidelines in a rather a twilight zone. Well, that's what I'm saying, that the court was very, very guarded, Miliz, in this, in spite of, and interestingly, in this particular dispute, court said they should be heard. So even the on
That
the
was in which year? 1978.
yes, Malathi. Malathi, the
44 years ago.
December 2, 1977. Yes, Malathi.
Yes, then.
Well, the one more, just one para in that, the 1986 4 SCC, page 78, para 15. There, the prayer was made that the appointment method of election commission be equated with the judges. Court said
Refused.
That's the, I think, Malaj, that was refused in that case.
That was refused. 86 or 96?
Well, this says 1986, 4 SCC, page 78, Malaj, and para 15.
Yeah.
Well, as if I summarize what I wanted to point out was, but the first is my humble submission looking at the scheme which has been there right from 324, 324.5, respective law being made, people representation being there. This is a scheme in itself, even if looking at the Constitutional Assembly debate in terms of reading the mind of the constitution makers. There is no vacuum which today.
No vacuum.
Yes, that's the first submission I have, Malaj. Second submission is that why subject to law has been put in 324.2, noting the background debate on that aspect, is that the freedom has been given to the parliament with the test of time. What is the time and what is the stage and what is the event should be the time when this should be exercised. Before that, the process which has been provided, if that process has got any error in terms of functionality of the commission, then this court is there to look into it and has been corrected on a numerous occasions. Therefore, this not is going to mandate to say that, well, if this argument would have come in 1960, assuming for a minute, and this would have been looked at from the point of view, say, no, you please frame a law in 1960, a law should have been framed. That could have been there, and today the situation. And with walk of life, I don't think the society is going to improve. The distrust and mistrust is going to increase by virtue of integration it has emerged in the society. So there can be a different features today we may not be even contemplate. And like in that privacy judgment, Justice Nariman said that so far as at the constitution making stage, the privacy would have been a very different meaning. Today, with the technological developments, it has completely gone into a different realm. Even terms of a location, geographical jurisdiction, nature, simple comment. So contemplating that these are the changing dimensions which will come. And underlying fact is that today there is no pointed fact which requires that some correction is there. No trigger point. That's the third thing which I want to point out. Fourth is that the test of Vineet Narayan or test of Vishaka which has been sent, two fundamental factors which are extremely important. One is there was a trigger. Second, there was a consensus where the union also was wanting that since there is a vacuum of any statute existing and not going to the umbrage of constitution to say that there is some method has been given. In that, even both the parties sat together. That may be IRC report, or that may be Vishaka Para 16, where it has been taken into note that we both agree that this is the area which is to be done. Third factor, which is important in this case, is one of those are the cases which are to be tested to the extent of violation of 21. So we are going to pitch, and those are the individual rights which are created. Today also one argument can be that somebody who's going to go vote, he has got a right to vote, and therefore there can be a breach if independence is not there. But when we look at those judgments, I think the fundamental point was that if there is a impact on an individual, life and liberty aspect comes into it, and or there is some grave failure, like CBI couldn't file in a charge sheet in time.
Tenuous.
Yes, Manoj. That is the third thing which I want to point out, Manoj.
Tenuous.
Yes.
Then.
Fourth, Manoj, is the efficiency and independence is not in dispute today. And desirability can't be a test to step in, Manoj.
That's we have seen.
Last, Manoj, the reports have been a troubling point for my lords because my reports been saying, Manoj. There is a contradictory, in the same pages what we have read, Malaj. The simple example I'm giving, they're saying the independent secretariat there, but the charge can be through vote. There's no need of a charge on a consolidated fund. It's fine. So those kind of are there. And most important answer, these kind of reports have been considered. One I pointed out in case of a judge's case, Malaj. And second is these reports are a constant endeavor to upgrade the administrative functioning of that.
Correct.
So whether those are to be treated as sacrosanct at every stage and necessarily to formulate it in law, in my respectful submission, may not be the right way to look at this. And the last being, Malaj, whom we are today doubting in absence of any action, are people with the administrative experience of 30 years. There is some check with the government which is maintaining, and we have not come across somebody who's been a fundamental charges have been leveled against any particular commissioner, in spite of that Ganguly and Tendulkar battle going on between them, which has come to a number of times. No, at no point seriously this has been pointed out saying that the man of zero integrity has been taken up and these are the charges against him, and therefore that's not a test even has been.
Is there any prohibition against them getting an assignment after they vacate the office of election commission or a chief election commissioner?
But there is no
No bar.
bar in that.
No bar.
There is no cooling period. There is also no cooling period also. There is no prohibition in that and there is no cooling period.
Yes. Historically, have they been given subsequent assignments?
But I understand in one particular. No?
There's no assignment. After you deliver, there's no assignment.
All right. That's the more credible.
But if I'm not wrong,
No bar.
in civil services, there is a cooling period. Those who retire, and there is a cooling period of 1 year or 2 years.
1 year.
I think 1 year is there, cooling period is there.
Yes.
Under that. So this was not considered that. So this appointment as election commissioner is nothing to do with the cooling period there.
It's nothing to do.
So the day you retire, you can become an election commissioner. So where the cooling period comes in?
Pradeep, that's what I was trying to find out.
No, the cooling period is there.
Yes.
Now where it will apply, we don't know.
But the interesting part would
In
be
civil service, cooling period is there.
civil
But every
service.
2 years, it used to 1 year.
So would it be equated the constitutional position? These are not just some advertisement is being given and application. This is based on a judgment, which is based whatever factors are taken into it. So equating the constitutional appointments and equating the civil appointments will maybe a little different, where the rules and regulations are far more stringent to make the administration function and control knowledge. So broadly, in light of these submissions, my respectful submission is that there is the existing machinery which has worked well.
Thank you.
This may not be the stage, Maradhi. I'm so grateful.
I think the fundamental
No, what do you
point
want to
that
say?
you have,
What do you want to add? Virtually everything has been said.
I'm
the
sorry.
fundamental point that you are trying to raise is, brother, just one,
Sorry, go ahead.
is that these very machinery which is in place, the officers who have been selected, they have regularly conducted election all these years
Please.
without any, and the voting has also been to the extent that is expected.
Yes,
So therefore, there is no trigger point, that's the word.
that's right.
And the headaches that you have used the expression
Please.
are obviously something which can be taken care of on a case-to-case basis if there is a breach of fundamental.
I'm grateful. That's what I want to point. I'm grateful.
Yes, Mr. Mehta. You can say.
Well, I will not repeat anything, but
You're also appearing for Union of India only.
yes, for Union of India. But I am coming last, my lord, more logistically, my lord, not that.
Union of India, yes.
Yes, please. My lord, to answer the first question, last question first. whenever the constitution has envisaged that a person who holds a particular office will not get any other assignment, as my lord rightly put, the constitution has provided.
There is a bar.
And that is under Article 148 of the Constitution,
That's what,
Comptroller and Auditor General.
no such bar.
There is no such bar. Lord, what essentially, my lord, we are debating on petitioner side, respondent sides, and troubling your lordship, what the constitutional provision should have been for an ideal appointment or an ideal process of selection of election commissioners, my lord, which, in my respectful submission, may not be a subject matter of proceedings either under 32 or otherwise. If there are any lacunas, if at all, and I will point out there are none, it is for the legislature to fill in, not by an act of parliament, but by a constitutional amendment.
Here, Mr. Solicitor, the triggering thought for this is all these reports, law commission, etc., are somehow saying that it needs to be changed. So that is the,
Lord,
we call it a triggering thought.
correct, my lord. But the triggering thought, my lord, is always welcome. That necessarily, my
So
lord,
whether it's a constitutional thought or not,
the law or anything develops because of such triggering thoughts. But the question is, which forum will make that change? No, that's essentially the argument we are making. My lord, now kindly take the constitution, my lord. For my satisfaction, I am not repeating, I am, my lord, assisting your lordships in a different perspective. Kindly have, my lord, 324.
Please, got it in our mind, yes.
No, my lord, it's always, my lord, a little satisfactory for a lawyer when your lordships have the bare act in hand, my lord.
Yeah.
Lord, your lordships may kindly come directly to 2. And the way, my lord, in which, my lord, the sub-article 2 is presented, I have a different perception to that. And your lordships may kindly consider that.
Yeah.
The election commission shall consist of the chief election commissioner and such number of other election commissioners, if any, as the president may from time to time fix, and the appointment of the chief election commissioner and other election commissioners shall. Now, Lord, mark this. Lord, this is the point which consumed your lordship's substantial time. Subject to the provisions of any law made in that behalf by Parliament, be made by the President. My lord, the initial impression, my lord, which one gets, and my lord, it has been given to your lordship, is that President will be the appointing authority. How the appointment is to be made will be made by way of a law as contemplated under sub-article 2. My lord, in my respectful submission, that is a wrong reading of sub-article 2. That's not the law which is contemplated, and I'll make that submission good. Subject, of course, to your lordship, meeting with your lordship's approval.
Yeah.
Kindly, my lord, takes Article 53, which is the law which is being contemplated. And then I'll again read sub-article 2. Kindly takes Article 53.
53.
The powers of the President. The law which, my lord, so far your lordships have been presented with, that there should be a law providing for a mechanism of his appointment. That's not the law which is contemplated. It's law under 53. My lord, please have a look at 53. Article 53. Lord, it is under the chapter executive, the president and vice president. I'll directly go to 53. The executive power of the union shall be vested in the president and shall be exercised by him either directly or through officers subordinate to him in accordance with the constitution. Leave it, we are not concerned, but not relevant. 2, we are not concerned, we are not relevant, I am skipping it, my lord. Please, my lord, now read, my lord, with me sub-article 3. Nothing in this article shall, that is the power of the president. A, your lordships may ignore, come to B. Prevent the parliament from conferring by law functions on authorities other than the president. Meaning thereby, in exercise of the powers under Article 53, sub-article 3B, Parliament can say that this particular power of the president would not be exercised by the president, but would be exercised by some other body. But I hope I am able to make myself clear. 53B is an enabling power conferred upon the legislature, namely the parliament, that it can, instead of president, invest the power upon someone else. Now, my lord, for my satisfaction, read 324B in this context.
So, 1 minute, is it this sub-article B, does it encompass all the defined powers of president?
Yes, all powers of the president.
Assuming in the situation, the president is the commander-in-chief of all the armed forces.
Yes, my lord.
Can parliament make a law today and say that no, not the president, but some other
He is
authority?
saying correct, your lordships are right, my lord.
I agree with the question.
Yes,
That is right.
but it's very rude to say yes, correct, to a judge.
No, sir,
Yes,
it's very rude to.
yes, my lord.
Can the commander-in-chief of the three forces?
I am reading, my lord, the way it is, my lord.
uh,
Nothing in this article, my lord, kindly see.
I mean, that's what,
It
so far
cannot.
as this litigation is concerned, that's possible.
No.
Academic, but this
The
one-
answer is no. The answer is in the article itself. Please read the article 1, sub-article 1. The executive power of the union shall vest in the president. So what can be delegated by way of a law is the executive power, not any other power. Executive power of the union shall be vested in the president and shall be exercised by him either directly or through officers subordinate to him in accordance with the constitution. Now that executive power,
that is an all-encompassing power.
not when he is the chief of the armed forces, he's not discharging
No,
executive.
that's a specific power,
The
yes.
specific power.
That's-
For example, power of granting pardon, etc. But here, my lord, all executive power, your lordship.
In Article 350.
Yes, my lord, all executive power is coterminous with the schedule. My lord, schedule 1 in list 1 in the 7th schedule. Lord, that is, my lord, now kindly read 324B 2.
Solicitor General, see, 53(1) speaks about executive power.
Correct, my lord.
The executive power of the union government shall be vested with the president to be exercised by him. Now, sub-article 3, which you are referring to, it speaks about nothing in the article shall, which you wanted to read, prevent parliament from conferring by law functions. There's a distinction between powers and functions. The executive power of the union, in the case of, is a head of the, is a head. Whether it is a ceremonial head like the Queen or
Yes,
the King in England.
yes, my lord.
The executive power can be exercised only except in 2 or 3 well-established circumstances. Only on the advice of the Council of Ministers. Now, how the Council of Ministers, who is to be consulted, it's laid down in under Article 77, read in the rules of business.
Correct, my lord.
Correct. So this may not have anything to do with it because we have no difficulty that the president's power has to be exercised.
I'm sorry.
Under 324B on the basis of the Council of Ministers' advice.
So 324B neither uses the expression power nor function. It says the appointment shall be made by the president.
It's a power. It can only be a power.
That's how your lordships can read it, but it can be read even as a function of the president. And that may perhaps not make any logical difference so far as 3B is concerned.
Yes.
It is that law which is contemplated that unless the power is conferred on someone else, the power will be exercised by the president. It's not dependent upon a legislative power. And I tell you, lordships, the reason. What is the object? Because there are certain functions.
While interpreting
Can
the
I-
provision, come out what you want to convey properly. Because we find it difficult. If you see 53 once again, and 1 and Article 3 is a clause B again,
Yes, ma'am.
I pointed out to you, something is missing in between. Please see. 1 is exclusive power of the union vests with the president,
Correct, my lords.
or to whom he authorizes. Absolute, no discussion. If you come to 3, nothing is article shall be prevent parliament from conferring by law functions. As you've been told, executive power Absolutely with the president. 3 only says functions or authorities other than the president. So if there is any other function which are delegated to authorities other than the president,
My lord,
this,
suppose,
by virtue of this clause, you can modulate and
take an example.
take away the power, the functions other than the president, vested with some other authorities.
Take an
But as the
example.
president is concerned, we don't think this B has any.
Lord, take an example, my lord. Parliament in exercise of powers under Article 53 3B makes a law that the power or function, whichever nomenclature we may give, under Article 324 2 shall be exercised by a body consisting of A, B and C. That is permissible.
That's
But if that is not there, then the president will have the power to appoint.
that is what is specifically provided in 324B itself. The making of a law by Parliament is contemplated in 324B itself. You don't have to go to the 53B for that. Because also you will see nothing in this article.
Yes, my lord.
53B speaks about nothing in this article.
Correct, my lord. That is one.
One.
Yes.
We are concerned with a separate chapter of the Constitution, which has a separate scheme. Even in the debates of the Constituent Assembly, initially the provisions relating to appointment of the Election Commission was contemplated as chapter to be included in the chapter on fundamental rights. They attached considerable importance to, so devoted a separate chapter to the Election Commission, dealt with in a standalone provision, then followed by 3-4 provisions which make up the whole chapter. The making of the law by Parliament, if you see the entire discussion, they had a lot of debate of what is going to happen if the president is going to be given the power. So they said somewhere down the line, they expected that, okay, if a situation arises, Parliament may step in. You can argue that, that period has not stepped in because you have got a very efficient setup. People are being appointed. Down the line, there are all very good people. So there is no trigger point. Parliament, it's a matter of wisdom. It's not a matter of legality.
I'm obliged, my lord. I could not bring
And
my
I can
own
understand
vote,
that there is a difference between power and function.
Yes, my lord.
See, with respect to appointment, see, for example, the judges, the power is exercised for appointment.
Was
But then,
used to be, my lord.
see, administering ought to the Chief Justice.
But used
It's
to
a
be.
function.
But used
It's
to
not
be
the power.
Used
So
to be
there is
exercised.
difference.
My lord, used to be exercised. I don't want to go into that, my lord, controversy, but
So there
power used to be
very
exercised.
carefully these words are used.
And my lord, it is during that exercise of power that we could, that system gave Justice Krishna Iyer and Justice H.R. Khanna. Thereafter, we made a better system, my lord. Recently, there was an article, my lord, yesterday or day before yesterday, where, my lord, some expression was used. I may not agree with Mr. Dushyant Dave in everything, but I agreed with that, my lord. But now, without using the expression which he has used, my lord, that this honorable court has usurped the power of the president. I don't use, my lord, I don't agree with that. Be that as it may, well, that's not the question, my lord, right now for your lordship's consideration. So your lordships are right, my lord. But, my lord, my respectful submission is, and I leave it at that because that's not a submission, my lord, in vain, submission in air. Your lordship's reading of Article 324B2, that in absence of any power, how do you exercise the power? My respectful submission.
There no difference.
I'm not, there is, nobody says, my lord, there is no power.
Nobody has a case that there is no power. Point is whether
Correct,
it's come to a stage where.
But, my lord, if there is no methodology of exercise of power prescribed as suggested by them, then, my lord, my respectful submission is that constitutional silence, as, my lord, a good word, my lord, fell from your lordships, cannot be filled in by way of a judicial interpretation. It can be done only and only by the parliament.
Okay.
That's, my lord, the position. My lord, now, yesterday, my lord, during the discussion, my lord, there was some debate as to whether presence of someone who is, my lord, I would say non-executive person. Lord, your lordships are aware, my lord, the separation is very clear. Judiciary, executive and legislature. There is a theory of doctrine of the doctrine of separation of powers. Lord, your lordships were pleased to, my lord, just mull over it, my lord, as a, my lord, loud thinking that maybe the presence of someone else might ensure, as, my lord, going by the reports, that things are not messed up. Look, there I have a serious problem, my lord, as an officer of the court, and please don't take this otherwise. This is my submission as a constitutional proposition, not individuals or institutions, as a constitutional proposition. But constitution makers were very, very clear that some of the powers are vested upon executive and legislature, and some of the powers are vested only on the judiciary. The distinction was some of the powers the constitutional framers thought should be entrusted to the people's representatives chosen by the people, who are answerable and accountable to the people every 5 years. That's why, my lord, this separation of powers. One organ will not entrench upon another organ. Second organ will not entrench upon the third organ. That's how, my lord, the balancing system in the constitution functions. Now, my lords, if your lordships were to consider that someone else, the presence of someone else might help the situation, what are the problems? Constitutional problems. I'm not on individuals or institutions for that matter.
Why are you asking someone else? We never proposed someone else.
No, there was a, my lord, that for example, my lord, presence of the Chief Justice of India or some judge of the court, well, that fell from as a
There is only a kind of a deliberations going on.
no, my lord.
Someone else.
Therefore, my lord,
We never said someone else.
if that was deliberation only and not going to materialize
There was
in,
only deliberation going on.
Yeah.
Nothing. Someone else you have come.
then I have nothing more to add.
Someone else.
I have, then, my lord, I have nothing more to add.
No, Mr. Virat. According to someone else means whom?
My lord, I didn't want to name, but my lord, as suggested, that for example,
It's my
presence-
submission. It's my submission which I've made.
That's correct.
I'm making clear.
You make a submission.
then, my lord, let me deal with. Let me deal with. His
That is for our
submission.
consumption.
No, absolutely. So I don't want Mr. Mehta to have the impression that we haven't made that. We have made that. I've made that submission.
I'm grateful to my learned friend. my lord. Lord, his submission is, my lord, let me put it this way, that there should be a presence of someone who is not a part of the executive. That's the submission, and I'm meeting with that submission.
Absolutely.
Did not fall from
That's
it.
also sufficient. That's correct.
Yeah.
That's correct.
But now, the problem is this. That would necessarily involve a process of rewriting the constitution. That's the first problem.
Correct.
Second, the moment this honorable court says that but for the presence of a non-executive, maybe my lord, from the judiciary, but not a part of the executive, the selection would not be proper, would depend upon true presuppositions, my lord, which your lordships will presume. A, it is not possible that the executive alone can discharge the functions constitutionally conferred upon it in absence of some outside presence, which negates the very concept of democracy, and democracy is in the preamble. It's a basic structure of the constitution. Executive consists of the people's chosen representatives. If one finds that one representative is wrongly chosen, that's his problem. Democracy works like that. Democracy works, my lord. He has selected one person to take all executive decisions, and your lordship's decision would not, in my respectful submission, be based upon a presumption that but for an outside presence, the executive will not be able to discharge its functions honestly or with transparency.
When you say that, historically, look at what happened in the CBI director's case.
I'll come to that.
Is not the CJI participating easy?
I'll come to that. I'll come to that, my lord.
So the democracy, when you talk about democracy, we don't want to say many things, but we just want to say that our court's history, our judgments, how our courts are approached, how the executive has accepted it also. There's no difficulty about it. CJIs do participate.
I'm not on individuals or institutions.
We are talking about.
I'm on constitutional proposition.
There we are talking about. This is also part of democracy. The CBI director, vigilance commission. I think CVC.
Let me answer that.
They're also.
Lord,
saying-
they're the basic. Anything I can. But appears to be something very interesting, though appears to be privileged communication, my lord.
No, it is just that, you know,
Sometimes, my lord, lighter moments are always.
like a moment we are discussing, I've got a very lengthy miscellaneous my list on Friday.
No, that's my lord, what the theory we used to, my lord, learn in first year of law, voluntary non-fit injury, my lord. Yeah, your lordships have taken that injury voluntarily, my lord, can't be helpful.
So you were saying about the
Yes, my lord.
CBI
Please,
director.
please, Lord, CBI director before Vinit Narayan judgment, Lord, was merely an officer of the government, not even a statutory functionary. Please, Lord, bear this distinction in mind. A mere officer, a statutory functionary, and a constitutional functionary.
Correct.
CBI director was a mere officer, was not even a statutory functionary, even till the law was subsequently amended. There was a vacuum as to how the person is to be selected. And the selection process by way of a constitutional mandate was not conferred upon the highest constitutional executive functionaries. Therefore, in absence of any, my lord, provision, your lordships, my lord, as a mere stopgap till the legislature steps in, because it was an unoccupied field, your lordships, my lord, said that. My lord, I would very earnestly urge, as a constitutional proposition, not to compare director CBI with a constitutional functionary, because, and my lord, I'm a word of caution, my lord, as an officer of the court. Similar provisions are made. Comptroller and Auditor General of India is elected in this under the same is selected or appointed under the same procedure.
The same procedure.
Governor is also appointed under the same procedure. Now, if the argument is to be accepted, Lord, would all constitutional functionaries be appointed by the executive necessarily with the help of someone from the judiciary?
You understand?
Lord, my lord, I very earnestly and with profound respect, my lord, and as a constitutional proposition urge the theory of independence of judiciary and theory of independence of executive are equally sacrosanct under the constitution. That's a constitutional proposition. We cannot say that anything which interferes with the judicial organ of the state violates the independence of judiciary, but executive function can be interfered with, constitutionally speaking. It is equally sacrosanct.
Separation of powers.
Separation of powers, my lord. And therefore, my lord, I'll cite only few lines from some of the judgments, not the full judgments. It says the doctrine of separation of power stems from Article 14, equality. All three organs are equal in the eyes of the Constitution, and no one organ predominates the other.
It just straight away give those citations.
But I have, my lord, it is ready.
So we would like to.
My lord, I can't run against the time, my lord.
No, we want, because you know we have got a sort of time frame, and your points you have really very, you know, in your characteristic way you have put across.
Yes, I do.
Which cannot be missed by anyone.
No,
It is
I
not
wish,
going to
I
go
wish,
on
my lord,
and
yes.
they're going to think about it, ponder about it.
And my lord, no, my lord, sometimes, my lord, it may not, it's not a difficult,
We are not saying. We are
it's a
saying
difficult responsibility.
very serious issue. We have to.
Lord, it's a
restore
difficult
it.
responsibility, my
What will
lord,
come of it is a different matter.
but, my lord,
We are only saying we have to give it a very serious thought what you are pointing out. A very serious consequences it has.
but I can
That-
read the,
that is all that-
I'll not,
Yeah, we are saying
I
that.
can't
We are
do.
saying that we are raised a very serious. We are not.
so, my lord, the
We will-
first problem is that non-trusting the executive, that but for an outside interference, they would not be able to discharge the constitutional function is constitutionally impermissible. And second, again, my lord, a very onerous responsibility to make this submission. But please take this as a constitutional proposition, not, my lord, otherwise. To, my lord, presuppose that it is only when there is a presence of one of the organs of the state, namely the judiciary, that transparency, accountability, and all other good things can be achieved, will also be constitutionally, my lord, not a correct position. Lord, we have bureaucrats. Bureaucrats are doing amazing work. They are deciding policies of the nation. They are deciding what are the nation's national policies with other countries. My lord, there may be inefficient bureaucrats. There may be inefficient politicians. There may be corrupt bureaucrats. There may be corrupt politicians. But this is the position in every sphere of life. So mere presence of someone from one organ can only ensure transparency, maybe, my lord, a fallacious fundamental foundation to make an argument on, which, my lord, my learned friend has, my lord, sought to make. Well, that is, my lord, my second submission. My lord, therefore, the lordships may kindly not, my lord, travel through that path which disturbs the constitutional balance of separation of powers. Because that might, my lord, we have to tread very, very carefully.
Absolutely.
And my lord, it might, my lord, why enter into an area which might have a
Very delicate. What you said is right. It has to be done, whatever has to be done, it has to be done with a lot of care.
Yes, because my lord, I at the cost of repetition say the independence of executive within the bounds of the constitution is equally sacrosanct.
That's in Article 50 also.
Yes.
The directive principle.
Yes.
There can't be two opinions about it.
Yes.
Absolutely.
Absolutely.
What we put to them also and what I put into you also, in 324(2), it says subject to the provisions of any law made in this behalf by the parliament, be made by the president. Our question is, where is that law as on today in place which permits you to proceed and process the names for appointment?
I bow down. I bow down. My lord, that presupposes my 53B argument is not accepted for the time being, my lord. I presume that, and my lord, I go further. Because my first argument is that law is taking the conferring power on somebody else other than president. In absence of that law, the president will have the power. Look, suppose sub-article 2 is read as my lords have, my lord, kind enough to, my lord, say, and there is no law, then your lordships would make a suggestion to the parliament. Look, there can't be a mandamus to the parliament, nor there can be an attempt to create, to fill up that constitutional silence by way of judicial interpretation. Because we are dealing with Constitution of India, not a statute.
Would this solicitor then suggest that the court should not undertake the exercise of saying what should be the process, but can certainly nudge the executive to do something which is expected to be done under
Yes,
324?
yes, that certainly your lordships can do that. But that in absence of the law, this will be the law. Till you make the legislative enactment will not be, my lord, constitutionally permissible.
All right. Okay.
Because we are dealing with a constitutional provision and not a statutory provision.
So we can now take from your statement that all appointments which are being made on the respective post of election commissioner or a chief election commissioner, they are randomly made on the basis of whatever the mechanism you consider to be appropriate. There is no law on the place.
Let me answer that, my lord. Let me answer.
So you
It's a
said,
loaded question.
you said that we have not come out with any law with the law.
Lord, my
The
answer is
Constitution asks
that
us.
Lord, it's an enabling provision, not a mandatory provision.
You could have said that, all right,
It's a
it's not mandatory, we have not followed it, still we have a mechanism in place,
Lord,
which is impartial and unbiased.
kindly appreciate, my lord. It's an enabling provision. In absence of any law, it's not as if appointments cannot be made. No, my lord, this is something serious.
Yes.
Lord, the Constitution has conferred that power on the highest constitutional functionary, and he has his own way of appointing. My lord, I cannot, my lord, give an example, otherwise I would have given an example. My lord, all constitutional positions in all three organs of the state, including judiciary. There are no rules or there are no acts of appointment. Your lordships as a collegium do take into consideration intangible facts which are not written down somewhere, that this would be the seniority, this would be the marks for judgment writing, mark for personality, mark for court behavior, etc. These are the intangible things. It is left to the wisdom of the people who are again constitutional functionaries. Here, President of India is the highest constitutional functionary.
You are not aware of. The attorney has given us a statement today, a written statement. And para 6 was read over to us. You have a copy?
Yes, I have read it.
It's something different. What you say is different than what is para 6 is different. Please read it. For clarification for us. You have it, this attorney, please have it. Let us have this para 6. Say, attorney, this was a supplementary submission on behalf of the Union of India.
Yes, no, supplement, today's submission.
No, because today so many submissions were made.
Convention.
By convention. Yeah, this is para 6 says by convention it has been established.
Yes, yes, Manoj, that's what I'm saying.
Have you read it?
The Honorable President, I have read, Manoj. The Honorable President has his own mechanism of selecting in absence of the law. But in absence of the law, which is not a mandate of the Constitution, neither the appointment would be illegal or can be termed as random, to say the least. These are all constitutional appointments made by the President of India, on whom power is vested by the Constitution.
You've understood, Solicitor. Nobody is suggesting that these appointments are illegal. And nobody has.
No, randomly made. Therefore, I must
what you're
answer.
saying is something different. What you're saying is, over a period of time from 1990 onwards, the government of India itself appointed committees, official reports, law commission reports, other committee reports.
Can be considered by the Parliament.
So that's a question. That's the only question.
Certainly, Manoj, certainly. Now, my lord, I come to, my lord, some of the judgments, and my lord, I conclude.
Yeah.
Lord, one more, my lord, just
give us, kindly give us those citations so that, and the paragraphs, which you
no, I have quoted and highlighted. I'll read only highlighted part, not even quoted part.
Just, you don't have to read it. If you just give us a paragraph and we will.
No, let me, my lord, give me 5-10 minutes more.
We are telling you, we'll go through it. You don't have, not as we will not go through
My lord, kindly, my lord, allow me for my satisfaction. Lord, kindly come to, first of all, page 16 of this. My lord, there is a new point.
Note, we'll see. We'll make a note of his written submission from Solicitor General. We'll go through each one of them.
No, I am not, my lord. Lord, page 16. My lord, my point is, the respectful submission is, whenever.
Judicial restraint.
No.
Judicial
Your lordship's I am sure your lordship's patience, my lord, I'm fully assured of. Page 16, my lord. Bottom. Lord, the proposition is this. Whenever the Constitution has envisaged consultation by the President in exercise of his function or power, it has specifically provided for.
That's a good answer. That is not argued by anyone.
No, Lord, I am not repeating any of the submissions.
No, that's right.
Lord, please see 98.3, consultation with the head of respective legislative houses while making rules of parliament. 124.
That's a new point.
Consultation with the Chief Justice of India, or as it stood originally, etc., etc. Lord, I am not reading all.
Replicated.
Therefore, my lord, if your lordship reads any other presence or consultation, would be necessarily, Lord, in my respectful submission, rewriting the Constitution of India. Lord, now, your lordship, my lord, kindly come to page 11 only, my lord, and I'll just, my lord, I'll make your lordships glance through it, that's all. I'll not read it, only, my lord, allow me to read the highlighted part. Lord, page 2, Samsher Singh is the lead judgment on Article 53.
Yes.
Kindly, my lord, come to page 4, para 31. Lord, your lordship's question, how the appointments are made, but as per rules of business. That's how, my lord, it is answered. The president acts as per rules of business. So in absence of a law, my lord, which the petitioner contend to be the law under sub-article 2, rules of business govern the field. And my lord, that's how, my lord, the constitution bench in Samsher Singh has held, my lord. My lord, I'm not reading it. I assume, my lord, your lordships would definitely, my lord,
Go through
read it.
each one of these.
Please read, my lord, Justice Krishna Iyer at page 6.
Yes.
Para 95, I'm not reading the entire thing.
Yeah.
We are not unmindful of the agitational siege of parliamentary institutions and the anti-parliamentary build-up underway and the rashes of frustration showing up against the unsavory politics of power. But the limited task assigned to us is to interpret the constitution as it is, not to venture starry-eyed proposals for reform. Even so, sorry, madam, I'm reading. Even so, our activism in interpretation must not be bogged down by logomachy or blinkered by legalism, but be aglow with insightful observations of Chief Justice Marshall. Then, my lord, 138 at the foot. The president in India is not at all a glorified cipher. He represents the majesty of the state. He is at the apex, though only symbolically, and has the rapport with the people and parties being above politics. His vigilant presence makes for good governance, if only if he uses what Bejhot described as the right to be consulted, to warn and encourage. Indeed, Article 78, Lord, then, my lord, it is Lord, very widely, my lord, that I'm just not to compare a power of President of India to appoint constitutional functionary with an officer like CBI director. That's not the purpose. Now, your lordships, my lord, I have cited TN Session. Next, my lord, your lordships may, my lord, kindly go through.
We'll go.
Only two, my lord, paragraphs I'm tempted to say. My lord, because of the prayers made, my lord.
Yeah.
One is, my lord, State of Gujarat versus R.A. Mehta. Lord,
Governor.
Lokayukt's appointment, my lord, where, my lord, very, my lord, succinctly, the Honorable Court has said, para 56.
56.
I give the citation, 2013, volume 3, SCC, page 1.
Is it part of this note?
No, it's not. Not therefore, my lord, I'll supply by tonight, by evening today.
Kindly repeat the citation once more.
I'll give that. My lord, 2013.
You're giving us a compilation.
Volume 3, SCC, page 1.
Yeah.
And, my lord, there are 5 judgments, all 5, my lord, I'll give. I rely upon, with para numbers I'll give. I'm not reading it. I'm reading only 2 paras. The principle of checks and balances is a well-established philosophy in the governance of our country under our constitution. If we were all to have our way, each person would be allowed to wage a war against every other person. This reminds us to abide by the constitutional law, followed by the statutory law. Otherwise, everybody would sit in appeal against the judgment of everybody. In view of the aforesaid discussion, the law as evolved and applicable herein can be summarized to the effect that the governor is bound to act on the aid and advice of the Council of Ministers unless he acts as a persona designata under a particular statute, so and so. Lord, similar are the, Lord, propositions. And my last submission, Lord, what your lordships are called upon to decide or adjudicate or hold is a general sweeping law, that till the law comes into force, this will be the law, which in my respectful submission, not permissible. Any outside interference would violate the theory. Last, if any appointment is made, which is the appointment of an unqualified person or otherwise undesirable person, your lordship's power of judicial review remains.
See, there is nothing like unqualified person because you have not prescribed any qualifications.
Lord,
How do you say that
there was a case where
you understand what you're
I'm understanding.
Unfortunately, you have not put in place, like in
Pakistan, wisely so.
Pakistan, they have put in place
But we
put it
don't
on
follow
a-
Pakistan
No, no,
mostly.
We are not.
And
considering-
that's the wise thing we do.
No,
Well, look at the position they have reached,
we
Malad,
are just
and look
talking
at the
about
position
what
we
is
have
there,
reached.
what is in the neighborhood? They have said, for example, how do you define a senior bureaucrat? Somebody who has 20 years. You are following that as a convention, fine. But when you say it is a qualification, it has to be prescribed.
I'm not saying that.
Cast in
Malad,
stone, you can
I
go
think,
for-
Malad, an
You
unwarranted
can say
use
suitable.
expression, Malad, is taken up. Malad, any appointment, if can be wanted to be challenged, can be challenged before your lordships.
On what ground?
In what it was, there
On
was,
what ground? On
no,
what
it
ground
was-
can it be challenged?
it can be, it was challenged, and your lordships were pleased to set aside the person appointed was having, excuse me, sir, was having charge sheets against him. There is a judgment of your lordships, my lord. I'll just, my lord, this is one of the judgments, my lord, in this, my lord. That was an appointment of CVC, I think. But the Center for PIL, my learned friend, my lord, has, and the name of the person was P.J. Thomas. No, not, yes. So, my lord, I'm not saying that your lordship's power
Chief Secretary of Kerala.
is not available, but the power is not available at pre-appointment stage to decide the manner of appointment. The power is after the appointment is made, if there is some ground,
Or-
of course,
Thank you.
these are the sufficient.
Yes. Yes. Bhushan.
Just 10 minutes. I will not repeat anything. Just on few things, that
You give a note, otherwise we'll not get anywhere. Please give
I
your
leave
note.
it to my lord, but because
You can give your note.
the whole thing is debated for the election.
Commission. He's election commission. Should be.
You make your submission, but strictly within 10 minutes.
Lord,
Just a moment, let us just 10 minutes he wants. Yes, go ahead.
Lords, at the foremost, Lords, I am not in the first matter, Lords. Election Commission of India is not a party, Lords, and rightly so, Lords. Because way appointment, Lords, we don't have a locus. So I am restricting it only to the second petition, which is Ashwini Kumar Upadhyay. In fact, my lords will see the prayers. It's a verbatim of all the reforms and proposals that we have sent to the Law Commission.
So you're supporting.
Replica of that, Lords.
You're
So
supporting.
what I'm trying to say is there's nothing new in that petition, Lords. From 1998 onwards till 2016, my lords, we had sent proposals after proposals, my lords, and it's my lord knows that the Law Commission has also proposed that we should have an independent secretariat, my lords. Also, my lords, insofar as the removability clause of the lords, insofar as election commissioners are concerned, my lords.
As they say, man proposes, God disposes.
So, my lords, my submission is, my lords, that should be looked seriously, my lords. Because today's time, my lords, when we go through the parliamentary debates and all, my lords, those times have changed now. And as rightly put forth by my lords, that now there cannot be a single manned commission. It's not possible practically today, my lords. So in that, in fact, even in the constitutional debates, my lord, it has been debated. There were objections even with regard to the removability clause, although it was not taken up, my lords. And Dr. Ambedkar probably said that, we are running short of time. So that is the reason why it was not debated in so much of detail. But my lords, in today's time, when you say that you are co-equal, you exercise same powers, and if two of them, my lords, have taken a decision, they can take a decision, majority decision. Now, when you give so much of right, my lords, that you can actually decide an important
So
issue
what
on
are
the basis of it.
what are you suggesting?
So what I'm suggesting, my lords, that the same, my lords,
Same.
because it has to be by way of a constitutional amendment, my lords. That's
Exactly.
the point, my lords. We can't really go beyond that because the constitution very specifically says so, my lords. So I can't really go beyond that. But, my lord, it should be looked
It looked
on because
into
we
and
have made those
they
proposals.
should make an amendment to the constitution so that the election commissioner should be put on par with the in regard to irremovability.
Absolutely, my
This
lords.
is what you want.
That is one point. Lords, as far as the, my lords,
And second, with respect to the commissionerate, the secretariat.
please, my lords. As far as the secretariat is concerned, my lords, now the commission works throughout the year, my lords.
So what is it that you want actually?
Because we want an independent secretariat.
Independent electorate.
Yes.
So what
Even
is
the budgetary allocation.
It should be charged, budget should be expenditure should be a charged expenditure.
Absolutely.
Like the salary of the judges of the High Court,
Absolutely.
Supreme Court. So it should be. So what will that not involve the court foraying into a matter of policy financing,
But
telling the government to make it
my lords,
consolidated.
insofar as these issues are
And if
concerned,
they make it consolidated, they put say 1 lakh rupees or 2 lakh rupees.
no, my lords,
This is
when,
salary of
when you
your-
have a revocability clause, my lords,
how do you
which is
tell them
compared.
what amount should be put? How do we tell them what amount should be put? Well, that should be charged. Otherwise, it's meaningless.
This can always come out from some kind of committee or consultation, my lords, which can look into it, my lords.
That's a,
That's
budget-
a
that's a
point.
budget
We can ask them to look into it very
So that,
seriously
because-
and come out with
Because
something.
obviously, my lords, all the
Budget
finances and economical issues have to be dealt with.
that's a budget.
The law commission has proposed that I can show that what.
That's
law
right,
commission-
that's right. Let us see.
Because, and because there was one.
They have all heard you, your submission. The complaint which you are making to us, they all have heard.
We have also. put it to
Attorney,
them. We have
attorney,
also-
solicitor, both have heard, but they're not.
Because it's on record, Vilots.
And
It is
attorney then
properly,
will,
it's,
that
we have
is
said
also
so
the-
in so many words in our counter affidavit.
You're putting them to shame, actually, that they're not able to.
Because there's nothing like that. Because what,
Better we have a
That's the beauty, that's the beauty of, that's the beauty.
because that in fact also shows that, Milord, I mean, I should not say that, Milord, but as an officer of the court, I can say that the projection is,
Why shouldn't you say what you wanted to say?
Milord, what I want, as an officer, I can say this, Milord, that the projection is that unless and until there is a mechanism, whoever is an incumbent is not doing his job.
Oh.
So, Milord, we've been working, Milord, I've been being a standing
Please repeat.
see our affidavit.
Please
So,
repeat your
as an
submission.
officer, I can say that, Milord.
Please repeat your.
What I say is, because as an officer, Milord, that the impression which has been given from the petitioner's side, that till the time there is a mechanism at place,
For what? For appointment?
plus for appointment,
Ah.
the present election commission or in past, Milord, they have never worked.
Very good.
No, such a submission has not been made.
Because there was a,
In fact, no.
Milord,
You see, that's pointed out also. Such a submission, I mean, don't take it to that level. In fact, what is being suggested, and Mr. Balbir Singh has rightly said that we have conducted elections on time. We have had good people, number of voters participating. So therefore, the system that is in place is, you can't say that there are aberrations there.
there were some suggestions.
No, sorry. There is no complaint.
Don't go
made.
by that.
That's-
You don't have to answer that.
Yes.
way.
Came from my lords.
Oh,
that
sorry.
was a-
Nobody has said. Sorry, nobody has said.
Because the
They
second.
they are completely silent on this issue.
No,
They
no.
never said that whatever the elections have been held in past so many terms, there is any kind of a aberration there. No, nobody has said.
Milords,
Only with respect
No,
to
no,
the
not-
strengthening
let
of,
me- let me put
strengthening
it-
of independence.
right, but the strength of
Strengthening of
council,
independence,
because as
that
an
is
officer,
what
I
they
can
have.
say, Milords, I'm strengthening Milords.
Now what
No,
you
no.
said is not that.
Let me put it this way.
Strengthening
Just
of
because we are
independence is
uttering the name of Sheshan every now and then, it doesn't mean that all the others have been,
No.
brushed with a
No, in
black
fact,
brush.
in fact,
Black
Milords, I
paint.
completely bow down when it fell from my lords that.
No,
was the
don't go
person
by. Don't
from
dwell on.
Where it started.
Don't trouble yourself on that.
Milords, the second is, Milords, insofar as Milords, there was a question which fell from this court, Milords, about whether a right to vote is a constitutional right or a statutory right. Milords, I will just give the judgment, Milords, with paragraphs right, Kuldeep Nair,
What's your stance?
UCL.
What is your stance?
Milords, it is a statutory right, Milords.
Not a constitutional right. Not a constitutional right.
Only insofar as a voter right to know about credentials, etc.
What do you say about 326?
Because 326, Milords, it doesn't give a right to a voter.
Why?
Because 326, I will.
Kindly read 326.
Yes, Milord.
Entitled. What is entitled?
Please read 326. I mean, you are the election commission. You should be telling us that they are.
Only for qualification.
No. We just read it. Very important that you read it.
Please, Milord.
What does it say?
Milords, election to the House of People
Yes.
and to the legislative assemblies of state be on the basis of adult suffrage.
Please read on.
The elections to the House of People and to the legislative assembly of every state shall be on the basis of adult suffrage. That is to say, every person who is a citizen of India and who's not less than of age on such date as may be fixed in that behalf by or under any law made by appropriate legislature and is not otherwise disqualified under this constitution or any law made by the appropriate legislature on the ground of non-residence unsoundness of mind, crime or corrupt or illegal practice shall be entitled to be registered as a voter.
So these are words which are, the lawyer knows, shall be entitled, 18 years, not disqualified. Now, if you are going to say that the parliament's power, when it sits in its legislative power, is going to override the constitutional power, the constitution has contemplated giving the right. That is a fundamental thing. It was 21 years initially. This is lowered to 18 years.
That's right.
At the time of the constitution, that is what the debate is. That ancillary lawmaking by the legislature is contemplated for giving it actually teeth and flesh.
Yes.
Just because the disqualifications cannot be enlarged by the legislature. What are the disqualifications are mentioned in Article 326?
Please,
can't be doing it.
Yes.
Now, if the legislature were to say, no, we will not do it, we will not make a law, certainly we would ban the Muslim. We'll say that you are defeating the constitutional right. I mean, fortunately, we don't have that position. But therefore, it may not be correct to say that Justice Chalamishra was not right. When he said there is a constitutional right, we have to, of course, how we have to modulate it, how do you state the law is a different thing.
Because
It has its
my lord,
underpinnings
I
in the
bow down, my lord,
Constitution.
but it has to be looked into from in a particular set of.
That's right. 13 Tennessee page 1 proceeded to analyze four judgments. But the effect of 326, we'll have to see because this is a larger net. We'll have to pronounce on it. All right. No, let us.
If your lordship is going to hear the Jellicut 2 at 3:30.
No, we like to conclude this first. We are not going to.
Let me then take.
We have got time. We have
25 minutes.
I've handed up a spiral bound. I'll just quickly finish in about 20 minutes. Very good.
But I have prepared a brief written note and rejoinder.
That's right.
Where I have, of course, this is one of those unusual cases where 3 law officers have appeared for the union. That's why we had fairly exhaustive arguments, and of course, finally the Solicitor General with his usual weight of authority suggested that we now undo.
Maybe not.
We will continue with Jellicut tomorrow.
Tomorrow morning, not
Certainly.
So today seems
Today we don't know.
Today it won't finish.
We don't know how things will go.
one can wait, one more happily wait, but I don't know if it will be possible.
That's right.
So tomorrow.
Then I have
Tomorrow,
to wait.
10:30 tomorrow.
That I will take tomorrow 100%.
No, tomorrow I'm here. I'll be here at 10:30.
We don't have to wait.
I'll be here.
Sorry for interruption.
I'll be here at 10:30. Sorry to interrupt you.
Fine.
Lord, I'll quickly run through
Yeah.
my submissions. So the Attorney General's submissions, my Lord, if I can summarize them, I have tried to summarize them here.
Yeah.
It says firstly that this court cannot issue directions to Parliament to enact a particular law in a particular manner. That was kind of supplemented or buttressed by or slight modification by the Solicitor General, who said that there is a separation of powers under the Constitution, and therefore this court can't even say or can't even tell the government or the president, can't say anything about how this power of appointments is to be exercised. Secondly, Lord, he said that the appointment of members of the Election Commission is in consonance with 324. Therefore, there is neither a vacuum nor the practice of appointment of members of the Election Commission can be said to be unconstitutional. He says there is no vacuum because government is appointing, government has been empowered, and so on. Then he says that merely because somebody aspires to have a better system doesn't mean that there is a vacuum. Then he says that there is no reason to think that the current system of appointment violates any fundamental rights under the Constitution. And then he says that the Law Commission report or the Dinesh Goswami Commission or the National Commission to Review the Constitution or the Administrative Reforms Commission have not suggested, have not discussed and suggested that the Election Commission is not neutral or that its lack of neutrality is because of this appointment being done by the government. Now, Lord, my response to all this is, firstly, we have not sought a mandamus to Parliament. We are not asking Parliament, this court to direct Parliament to make any law. Therefore, this argument of separation of powers is inapplicable. We are praying for this court to exercise its powers under 32, Red Bit 142 and 144 to issue a direction to the government to put in place an independent, rational, transparent system of selecting the members of the Election Commission till the framing of an appropriate legislation. Article 324 merely states that the appointment of the Chief Election Commissioner and other election commissioners shall be made by the President. There is no challenge to the power of the President to appoint election commissioners. The appointment has to be done by the President as it is done in the case of Supreme Court judges. Ultimately, the President issues the notification for appointment. However, the Constitution is silent on the selection and its process. In other words, the practice and procedure for selection is not defined. Further, there is no provision with respect to qualification for the members of the Election Commission. The government has also failed to produce any procedure that is followed by the executive, and therefore there is a vacuum, and this court can step in to issue guidelines on eligibility criteria, composition of the search committee, quorum of committees, and procedures that the committee must follow. Composition of the selection committee, Your Lordship, not the search committee, of the selection committee. Because it's...
Mr. Bhushan.
Yes. Yes.
Quite apart from the fact that this is a kind of a unique situation where we are trying to do all this in the context of a constitutional provision.
Yes.
Like an ordinary executive power, statutory power. This is the Constitution itself we are being asked to make an invasion, as he calls it, transgressing on the boundaries, separating each organ from the other, number one. We get over that. Whatever way we have, we can do that. Perhaps. Other more important kind of judgment starting like this from 1984 to SEC relating to adoption, public interest litigation, court issuing directions like Union Carbide, Ahmedabad Chief Judicial Magistrate case, and finally the judge's case. And of course the CBI director case and the court issued guidelines. They were all premised on one singular circumstance, which is that in the absence of any law.
Yes.
So to begin with, there is a vacuum.
Yes.
Now, here, the first question is whether there is a vacuum.
Yes.
Now, if there was a vacuum, it cannot explain how for the past 70 years, we have had a long line of chief election commissioners for the first 40 years.
Yes.
Thereafter, from 1989 onwards,
yes.
A short gap, and then from 93 onwards,
yes.
we have had also a multi-member team
yes.
being appointed. Now, is there a procedure for appointment? The president appoints means under a constitutional democracy as we have, Westminster model, Article 74, Article 77,
yes.
read with the rules of...
But I'm answering all this.
No, what you're saying is,
yes.
not a case where there is a vacuum which has produced a corresponding infringement on a fundamental right, which again in turn is a question which we'll have to ask ourselves whether there is a fundamental right.
Yes.
So you have to link all this together.
Yes, Lord. That's what I'm trying to answer.
Whether there is a vacuum.
Yes. So
also you missed out one important connection by the Solicitor General.
Yes.
Contended the belief that, or that is crept in, that only the presence of a judiciary will make matters transparent. That is impermissible. One should be impermissible.
I have not...
Such a contention was...
I have not argued that only the presence of the judiciary. I have said that there needs to be a neutral and an independent body to select election commissioners. And the fact that there is no neutral or independent body may lead to and has led to selection of election commissioners who may not be and often have not been independent. I didn't arguments delve into the question as to why there is reason. Now, this trigger point argument, if there has been no trigger point, etc. In the petition of the Association for Democratic Reforms, which was filed in 2021, my lord, we have not only annexed the report of the Citizens Committee, which details at great length at least 50 instances of the Election Commission not behaving independently. I didn't want to go into that because I thought it was not necessary for me to go into